The Governance Committee is coming to order. Yeah, right. Okay. Any public comment? Anybody here to publicly comment? Nobody. Okay, next, could I have approval of the minutes?
Motion made.
Second? All in favor? Okay, anybody opposed? All right, status of the 2008 MTA Board Corporate Governance Self-Assessment. Lamont, you're on.
Thank you very much. You should have in front of you the 2008 Board and Board Committee Self-Assessment. As you know, at the last meeting, you asked that we expedite the preparation of the assessment, which was initially scheduled to be handed out in November. So we did that, and you now have it in front of you today. We sent out 23 surveys, and we received 20 back at this point, for about 87%, which is an excellent return rate for this type of survey.
Yeah, make sure that's on the record. That is an excellent return, so that nobody thinks that we didn't do a good job on this.
Yes, this is an absolutely excellent return for a corporate governance type of a survey. Absolutely.
Is there anything in the survey that you want to bring our attention to?
You know, the purpose of the survey is really to assist you. So I try not to give my own opinions.
Okay.
I think there is a lot of good information in this, especially if you compare it to the survey that we did last year. I think that might be a very useful exercise. And again, you go through it, you look for those areas that are that indicate a large disagreement, if there is any. But I think generally speaking, I think the survey was very positive, that the general feeling is things are running well. And I think it was generally a very good survey.
Great. Thank you. Wonderful. Okay. Review and update of the MTA Board. Do we have to adopt anything on this? No, it's just a report. Pardon?
Yeah.
Percentage of folks that disagree on our commitment to transparency. I find that interesting.
What page, please?
7. I find that interesting, and, you know, not that I think we're not transparent, but it sounds like we have to go over and above everything that we've done to even be more transparent, especially to continue to refute all the negative, untruthful statements by Albany. So I would suggest that we actually look at that. Even if it's only one board member, none of us should feel that we aren't transparent.
Okay. Any other comments by anybody? All right, then, Jim, I think we're doing a review of an updating of the MTA bylaws.
Yes, when we last met, we were, Catherine Blue and I were working on a review of the MTA bylaws and those of each of the agencies to put them into conformance with the law that was passed and effective in early 2006, the Public Authorities Accountability Act. We prepared to bring that to you, and then there were some changes, as you all know, made in the law of great significance concerning the governance structure that were adopted in this May, effective, were passed, signed by the governor on May 7th. So as a result, we're now undoing the work that we did updating those bylaws and updating the bylaws to reflect the new governance structure, and we'll need to bring that to you at the next governance meeting. Those changes are fairly straightforward, and I have a presentation later in the meeting. I think it'll be things that you're already pretty familiar with because we had a prior session where we talked about what the changes in the new law are, but we can go over some of those changes later. And you know, the most central of those changes having to do with the new combined powers of the chair/CEO will affect the bylaws, and those are the changes we'll be incorporating into the bylaws.
Okay. Is that the update on corporate governance committee charter as well, or is that a separate issue? That covered that?
That's what we're going to do next.
Okay, let's do that, please.
Ready?
What's that?
Presentation.
Are we doing the item 9? Or are you?
No, we're at 6.
Presentation on recent developments.
Sure, go ahead.
That's your slides. I'm confused. Oh, I'm sorry. Okay, I'm sorry. We're doing the review of MTA policies pursuant to Public Authorities Accountability Act of 2005.
Okay?
Okay. What we did is we took a look at the requirements under Public Authorities Accountability Act regarding those policies that the board is required to adopt, and there are several of them, to make sure that, in fact, we were compliant with what those requirements were. Basically, it appears back in 2006, we took all those policies that related to personnel that were required to the board, and they were approved by the board back in April of 2006. It also requires that the board approve a code of ethics, which I'm sure you all know that you have done, back in 2007, and we are currently working on a new and improved version for you that we hope to have this year sometime, hopefully by the next committee meeting as well. And there are other things as well that, again, I'm not going to go through each and every one of them, but we checked, and all the required ones have, in fact, gone to the board. Now, the one thing that we did note in our review is that there are some policies that we believe need to be revised. They are all agency policies, which were approved back in 2006, but they are at a point in terms of aging out that they need to be looked at and possibly reviewed, and we're going to begin the process of doing that as well, and we'll bring those to you upon completion.
Okay.
And I have to apologize. It was my turn to be on. We're now, I confused item 8 and item 5. So we're now going to go to item 5 on the agenda, which is for the presentation of the recent developments. What we're talking about is the law that was adopted, passed by the Senate and the Assembly on May 6th, signed into law by the governor on May 7th, which we colloquially refer to as the MTA Financial Assistance Legislation. I think many of you are familiar with the basic changes that worked in our governance structure. Far and away the most significant of those changes is the change made in the position of the chair and its relationship to the chief executive officer powers. That change is very succinctly expressed in the amendment to the law, which is the first bullet there. Heretofore, in the PAAA, that's the Public Authorities Accountability Act, there was this effort made to separate the chief executive powers from the board functions. The Ravitch Commission, as you'll recall, recommended in December that in the case of the MTA, those powers be unified, the power of the chair and the CEO. And that's what this provision did, by stating the chairman shall be the chief executive officer of the authority and responsible for discharging the executive administrative functions and powers. So that's probably the single largest governance change that's in this legislation. And a corollary of that is that the chairman now, under the new legislation, is empowered to appoint an executive director and other officials and employees. So that's a change from both the existing structure. It's also, for the historians here who remember a time when there was previously a chair CEO, this second provision is a minor change from that, because in the pre-existing legislation, the chair had the CEO powers, but was required to have an executive director, and the executive director had some mandated powers, including the power to hire and fire. So this change in legislation not only combines, as it used to be in the past, the chair powers with those of the CEO, but it gives the chair a considerable degree of discretion in deciding how to delegate those powers, including whether or not to have an executive director and how to arrange the management authority of the MTA. So those are probably the two largest changes that are in the legislation. Next slide. In order to implement that, because of our complex structure, there's the MTA headquarters, but we also statutorily have two affiliate agencies, right? New York City Transit, Triborough, the TBTA. And so those both by statute have governance structures too, and so to make them all conform, the legislation provides that the chair CEO of the MTA shall provide those same functions for New York City Transit and for TBTA, and then obviously we have a number of subsidiary operating agencies, including obviously the commuter railroads and MTA Bus, and the statute provides that with respect to each of the MTA subsidiaries, the chair of the MTA is the chair of those subsidiaries and is the CEO of those subsidiaries. So those are what I call conforming amendments to make it all consistent. The mechanics of the implementation, let me just spend a moment on, and I think you're already familiar with these, but I'll just go over them quickly. In terms of when does this happen, it all happens upon the appointment of a chair to the vacancy that the legislation created. So an appointment for these purposes means not someone being nominated, but means someone completing the appointment process, being confirmed by the Senate. At that point, the person who is so confirmed will become the CEO as well as the chair of the MTA. The term of that appointment by legislation runs through June 30th, 2015. So depending upon when it commences, that's somewhere less than 6 years, assuming it happens this fall. The salary of the new chair CEO is to be determined by the board. And to prevent any conflict of interest in that, this legislation expressly provides that the chair is not to participate in the board's determination of the salary.
That's certainly a very difficult proposition, assuming, of course, someone had obviously had to have prearranged a salary offer for someone to accept the nomination. And if the board is going to decide the salary, and the statute requires the board to decide the salary, who's the chief negotiator?
Well, I understand that it is anticipated at the upcoming July board meeting next week that there will be an executive session at which the salary matter is to be discussed. I think it probably makes sense to do that in executive session.
Okay.
Aside from the unification of the chair and CEO powers, there are a number of other changes in governance that the statute provides for. Some of them seem like real changes. Others may seem like codifications of things we already pretty much did. I'm going to run through those fairly quickly. If you have questions, I can't speak for the legislature, obviously, but I can tell you what I think they were trying to say. There was the adoption into the legislation, into the law, requirement that board members appointed after June 30th of this year have experience in a whole laundry list of areas of experience. I think it's written very broadly and in a way that allows for members to bring a broad range of experience to the board.
Is it your position that if you were a transit rider, that covers transportation, considering how the legislation allows transit riders?
Well, I'm not sure that our having a position is going to matter a whole lot. My interpretation is that it probably means a little something more than that. But the reason why I say I don't know that it matters a lot, what our interpretation is that this is a requirement that's imposed on the appointing authorities. Since we don't control who is appointed to the board, the person, meaning the chief executives who are nominating and the governor who is appointing, will have to take into account this provision of law when making appointments. And so they'll need to select persons for the board who have experience in one of these broad areas, or, as the legislation says, other areas that are considered of material and significant to the operation of the MTA. So this is one of the many things that was included in the statute. Next, we go to I'm sure all of your favorite provision. The current law, existing law before this legislation was passed, provided that the governor could remove members from the MTA for inefficiency, neglect of duty, or misconduct in office. The legislature added the phrase breach of fiduciary duty to the removal provision. These
How do you determine inefficiency?
Again, I'm not sure that there's any history of a removal of a member from the board of the MTA. And this legislation language, as it existed prior to this amendment, was very similar for all the other public authorities. I think it's a provision that is extremely rarely used. There is a provision, I think, in the law that provides that if a member is absent from a certain number of meetings in a row, I think it's 3, but I could be mistaken, that the chairman or the appointing authority perhaps can remove. So that might be one measure of that, but again, this is a power that's exercised by the governor, not by our board, so our construction of it in the first instance isn't the one that counts. But this is the only change was to add the phrase breach of fiduciary duty. I think it's quite arguable that the phrase neglect of duty already incorporated that. Fiduciary duties are traditionally viewed as including a duty of due care and a duty of loyalty. Next. I'm now going to go through a series of provisions. They are in a lot of areas and in no particular order, which is the way they appear in the statute, but I'll just quickly sum them up. This provision, there's a provision that affects 2 parts of our capital program review board submissions. When the MTA submits to the board members at the committee level or the board as a whole the proposed capital program plan, at the same time we are now required to distribute the plan to the members of the CPRB, not as a formal submission that triggers the clock for approval, but as an informational submission. In other words, they wanted access to it as soon as possible. So that's now codified in statute. Secondly, our proposed capital plan is now to incorporate or address methods by which the capital plan, implementation of the capital plan will provide for maximizing participation by minority business enterprises and women-owned business enterprises. So that's a new aspect to the capital plan that needs to be incorporated. There are various reporting requirements that were added to the Public Authorities Law specifically. These are all provisions that are specific to the MTA. There are already lots of provisions that apply generally to public authorities and to the MTA. We have already submitted this report, for example. This report requires that we compile a lot of information that we already, I think, are transparent about, but now we compile it in one place in one new report. It's a report that comes out after our annual independent audit report. It's a report that includes information that's contained in our annual independent audit report, which we can reference, and includes things like our bylaws, our internal controls, description of our structure, and the like. This is all information that we already track, and it's a question of compiling it and including this report, which we've already done for this first year. Next. It also requires the new legislation that we put up on our website and submit to, when I say submit, generally the statute means the same thing. It generally means submit to the governor, to the president pro tem, and to the Speaker of the Assembly. In this instance, we're required to prepare a proposed mission statement and performance measurements for the MTA. And then each year we're supposed to re-examine how we match up to those goals and to those measurements and adjust them and self-evaluate based on that. In many ways, as everyone who's on an operating committee knows, there are, on a monthly basis already, the MTA and the operating agencies report to committees and have all kinds of measurements that relate to their performance. There's a project underway headed that Helena Williams has asked George Walker to spearhead to come up with the best template for the broad summary that would comply with this. An additional reporting requirement is, as you know, we already have a budget and financial plan process. The legislature has indicated they want us to do various things relating to that. One is posting our budget and financial plan. That's something that's easy to do because we already do it. So we're going to continue to do that, and there are a number of specifics that they provide in the legislation about it being in accordance with GAAP, which it already is, that be based upon reasonable assumptions and methods of estimate, which I believe the existing controller regulations require, and other requirements. It's supposed to contain a plain English summary. There is a requirement of, I'm sorry, can you go back? There's a requirement of quarterly targets that we establish. I believe the existing budget process does that already on a monthly basis, so I don't think it's going to be too much of a stretch for us to achieve that. It requires budget monitoring and posting on the website of our monthly projections. So there are a number of codifications, I think, of controls or reports that are, for the most part, presently undertaken. Next. I think you're all aware that the legislation creates, or has the chairman create, which the chairman has done, an office that's titled the Office of Legislative and Community Input. That office is conceived by the legislature as a way for members of the legislature, as well as for members of the PCAC, to communicate with the MTA in a way that their communications will be recorded and that responses will be provided. It includes. Yes, I believe we're supposed to make a record of inquiries. Inquiries can be questions. Inquiries can be comments or criticisms or proposals. So, our
Inquiries directly to the MTA, or all inquiries formally? Does that include inquiries that are made formally to this committee? Or does it have to include all inquiries made of public officials to all the members?
Or random diatribes in the press.
I don't think it would include comments that aren't made directly to the MTA. I do think it would be wise to regard members of the authority, the board members of the authority, comments made or questions or criticisms addressed to you. I think it would be good to have those communicating to the office so that that can be part of the compilation and preparation of responses.
So we could ask them to refer, if they ask one of us a question, can we say, please put it in writing and send it to you? Or do we have to write down what they ask and send it to you?
Well, you can't have it sent to me because I'm not the head of the Office of the Legislative and Committee Input, but I think it's appropriate to ask that, but I think if they don't do that, it should still be something that you undertake to communicate to the head of the Office of Legislative Input that this, I think presently it's Hillary Ring.
This might be a good moment just to say what the Brodsky bill, which has been passed by both the Senate and the Assembly, says, because it takes this one step further.
Okay, so the chairman is noting that I think last Thursday, when the Senate was in session, they passed a number of bills. One of the bills that was passed is a bill that had previously passed the Assembly. It concerns not just the MTA, but more broadly public authorities, and I think it's sometimes called public authority reform or oversight legislation, and it has a number of provisions, and amongst those provisions is I think it's called a lobbying contact provision. It is worded rather broadly, and I think I would not be exaggerating much if I said that as presently written, it requires MTA decision makers and persons at the MTA who influence decision makers to report all contacts, whether written or oral, made to a decision maker or someone at MTA influencing decision makers on any matter when the contact is made on behalf of another. So this is an extremely broad provision that obviously we have practical concerns about. Well, no, I think you guys are under this. I think you're in the within MTA side of the barrier. But if someone outside the MTA contacts you or contacts me, or contacts the CEO, or contacts head of procurement, or contacts
Including
anyone.
including elected officials and other people in the government.
Well, that gets into the definitional questions of what's a contact on behalf of another. I think that language is very broad, but presumably not so broad that it would include if a commuter contacts us or one of you to complain about a train not arriving on time, that seems to me not to fall within the ambit of this proposed legislation that's passed both houses. If someone who's the head of a nonprofit organization contacts us on behalf of the organization, it sounds like that falls within the literal language of the bill. So this is one of several provisions in this broad, what this public authority accountability or oversight legislation that is going to be presented to the governor.
So, for example, the gentleman that was talking about
Push your button, please.
the gentleman that was talking about the what was it, the CS or GS, the GS,
Yes is yes.
the CSG Corp. He was talking about it this morning.
No, it probably wasn't at the
No, he wasn't at the meeting, but he was talking about the fact that, he's been running the Central Station of Groceries Corporation for so long, and it was pulled. And I have found that, sometimes people want to communicate with board members, they'll send it to the offices that we work legitimately for during our course of our regular day-to-day life. So you're saying now that those things, which I have always forwarded, those things now have to be reported?
Yes, there's a requirement of, in this I can't say that under this new legislation it's not law yet. For it to become a law, the governor would need to sign the
Sign it,
legislation rather than
right.
veto it. But assuming it were to become law, it would have a very broad application, and it would certainly appear to include communications of that nature. Without derailing this whole thing and getting into far too extensive discussion, but we can talk about it further, there already exists something called the procurement lobbying law. So to a degree, certain communications that are made to influence decision makings in the procurement area are already subject to certain reporting requirements.
But under that law, I would think that something that was sent to me like this would just be an FYI. I'd look at it, it'd be for my information. All right, I'd see it and keep going. But for the Brodsky thing, what you're talking about is I now have to take this and send it off to the proper
Or to
authority.
take a different example, suppose it's not a letter, but it's a telephone call and that you receive, and someone's saying on behalf of what organization they're from that they understand that a certain matter is coming before the board, and they really think that you should, take their view of it. That it would, I think, rather clearly be a contact within the meaning of this proposed provision, and require a contemporaneous recording and require apparently us to have an officer who's in charge of the collating of all these reports, and they're supposed to be kept in a manner that makes them readily searchable. So this is not existing law, but it could become the law if this legislation is passed.
How about newspaper reporters calling?
I think, again, this requires further study because this is proposed legislation. We're reviewing it. My guess is that wouldn't be encompassed because on the assumption that a newspaper reporter is calling not to influence the outcome but to report. Well, whether it's true in fact or not, it's probably formally true. But again, this is legislation that isn't presently law, and it's legislation that we're reviewing. So I think it may make more sense to talk about the legislation that is the
The odds
law.
are it's going to be law, so don't ignore it.
Yeah.
Is there a portion of this one that's now sitting on the governor's desk that has to do with public authorities contracting ability?
There are a number of provisions. Among the provisions is a provision that concerns the role of the controller in reviewing contracts of public authorities. And the legislation would, if enacted, provide that for contracts of over $1 million of a broad variety, including procurement contracts, construction contracts, public works contracts and something called revenue contracts, which may have a very broad ambit. That those when a public authority, because this isn't specific to MTA, when a public authority intends to publish, bid documents or a solicitation for an RFP, before it does so, it would be required to notify the controller under this proposed law, and then await the controller advising the public authority whether the controller was interested in reviewing the contract before it's final, and in which case if the controller indicated it was interested in reviewing the contract before it was final, then the procurement documents would state that any resulting contract would not become effective and binding and final without the controller's approval. And it would provide certain timetables for the controller to indicate it was desirous of reviewing, or after which the passage of which would be presumed that the controller was not interested. And it would provide, in reviewing the contracts themselves, that if the controller didn't indicate approval or disapproval within a stated period, that it was deemed essentially approved. But this is in the proposed legislation as well.
Has anybody in our public authority, because this is a public authorities law, been able to determine the increase in cost that's going to be required as a result of this? I mean, when we get delayed and delayed and delayed because this guy hasn't approved it, I mean, this could really delay the whole operation of the MTA.
There seems to be there's a default mechanism. I mean, we have something very similar in city government that it's, once before we register a contract, the city controller needs to approve it. If after 30 days he does nothing, then it becomes, I think, valid. So that it's a way to, at most, it's a delay of 30 days. It's something probably similar, right?
Similar, but not the same. I think the concerns that Commissioner Sador adverts to are very serious ones. We have distributed the legislation to our procurement officers. We have real concerns about the impact on delays, because we know in the construction area, delay often means money. It also can create uncertainty. The legislation that's going to come before the governor has longer periods than 30 days for the controller to exercise such reviews, so potentially could imply delays greater than 30 days, depending on how it's construed. There's a 45-day period that's described, and then there's a 90-day period that's described. So there are concerns about budgetary and cost and bidding implications of the legislation that we and other public authorities presumably will be expressing.
What it means is that any time the board passes anything over $1 million, it's subject to review, and it can be overturned because the controller decides he wants to overturn it. So the board's role is, if not diminished, reduced.
I've always felt that, by the way, the contract role of the board has been an interesting one in the past. Personally, I don't have a problem with it.
If we go back to the May legislation that is passed into law, so you're familiar with the Office of Legislative and Community Input that has been created. It will be compiling comments and responses to comments, and it will have to issue reports based upon the comments and the responses to comments. Next slide, please. The legislature also included in the May legislation a self-authorization that it could engage an independent auditor to audit MTA finances and operations, and expressly provided that there be such an audit conducted in 2009. I'm unaware that that's been commenced yet.
Is this at their own cost?
Yes.
Or are they going to bill us for it?
The legislation does not provide any mechanism for MTA to be taxed with such cost. Next. We're also required to list on our website the law firms we retain in a given past year, which is readily done and information that was certainly already foilable and we would have been happy to provide. So we will be posting that information annually on our website. Next. We already have a program at MTA that seeks to promote the use of qualified transportation fringes We have a number of agreements with companies that specialize in facilitating employers providing these benefits to their employees. The legislation codifies that we do that we promote broad use of fringes to increase the participation by companies and employees in such companies. So we are engaged in reviewing what we're doing and seeing if there are ways we can make it even better. The legislation contains a notice requirement for our contractors on public works contracts that they facilitate awareness by employees of two provisions of state law, the whistleblower law and the key TAM provisions law. So it requires that we require them to post notices. So when we enter into contracts for public works, contracts with contractors, it's an additional notice requirement at the job site and on websites. And we have also posted that notice on our website. We're required to implement policies to minimize unwarranted expenses in connection with benefits and also the use of automobiles. We're reviewing, MTA has a all-agency use of automobile policy, so that's under review, but we have an existing policy, and so we'll be looking at that. There's a requirement that we try to develop a plan that will promote small businesses' participation in transit projects. As you know, we have a large capital program, and we also have much of that program involves federal funding, and there are various federal funding requirements. But what this is specifically about is state content. And this is an effort to promote both small businesses and businesses that are based in New York State and that manufacture and engage in business in New York State to have greater involvement in our contracting program. Importantly, the legislation makes it clear that we're not required to do anything that would be inconsistent with federal law governing our federal funding. So Transit and MTA are looking at this and working on developing a plan, but we're mindful that the legislation says what we do has to be appropriate and consistent with federal law.
Jim, in addition to that, and I see obviously it's drafted as a way to the extent practical. I see that it's drafted in a way to be the extent practical and gives us a lot of leeway. Does this language in itself trigger any reciprocity laws with other states?
Not in itself, I do not believe it does.
You know, that's similar to what we do already for the DBE program, which is the state end of the DBE, not DBE, the minority and whatever.
The MWB.
You understand what I mean. So there's certain processes already set up. Have we started developing a plan that specifically includes small business without the
I think you're aware, I mean, certainly Commissioner Metzger is aware that we have been working on the passage and development of legislation that would create a small business mentoring program, and I think that program, if we're able to do that, would go far towards satisfying this suggested requirement.
But the legislation we needed for that didn't go forward, is my understanding.
Not yet.
But wasn't there some other mentoring legislation that did go forward? And
yes,
can we slip under that anyway?
The answer is yes, and possibly yes. Yes, there was other legislation, far less detailed, that generally addresses the use of mentoring programs for small businesses by public authorities. It is fairly nonspecific, and so that's currently under review. It was one of the other things that was passed on that Thursday evening of, a week ago. So that's being looked at, and we'll be seeing what we can do within the confines of that law, too. Oh, that's it.
Okay, what else do we have to do at this meeting? Come on.
Update on Corporate Governance Committee charter. In the past, we have taken this opportunity to approve this committee's charter. However, I'm recommending that we not do that at this meeting, that we wait until the next meeting. I believe it's scheduled in November. There are going to be changes that are going to need to be made to this committee's charter and to each of the committee charters. So we'll start that process in September. I will reach out to each of you and start the process of discussing how we can make those changes to the committee charters.
Great, thank you. Anything else?
New business?
Ed Watt?
The, maybe I missed this, but the minutes talk about the 2009 committee work plan, which I assume is the same one as on page 4. And the minutes talk about adding a discussion on policies or report of finance committee policies vis-a-vis bond issuance approval. Process should be added to the next work plan meeting, and I don't see it.
My recollection is that that subject matter did come up here, and that I think I expressed the view that that was something that was appropriate for the Finance Committee, since that's the committee that has addressed these matters in the past and that addresses the resolutions.
Well, that's fine. I mean, it actually says in the minutes that Mr. Henley stated that he would follow up with the Director of Finance and CEO. So wouldn't, like I said, I may have missed it. Wouldn't that be reported here?
No, these are the minutes of this meeting. I know there have been subsequent discussions.
These are the minutes of the last meeting.
Right.
Right. So where is it appropriate to make those subsequent discussions? Or if there is something that, as General Counsel, you said, no, that should be taken up in the Finance Committee, that should be at least reported here.
I think that is reported.
It is
there.
reported there.
How's that?
The minutes are the minutes of what minutes of a meeting
Transpired then.
are exactly what transpired at that
I
time.
got that.
That's what they are.
Yeah.
Okay.
So I'm saying, where does the resolution of that issue belong?
Finance.
Has it already been
In
reported to the
in
Finance
finance.
Committee?
In finance.
Wouldn't it be appropriate to bring it back here and say that it was reported at the Finance Committee?
No.
In part of whatever your report was? That's all
No.
I'm
It
saying.
Never
I'm just trying-
happened.
No.
Sorry?
And it never happened.
It never
The
happened.
discussions have gone nowhere.
Okay. So wouldn't that be something for the Governance Committee to say, why didn't those discussions happen?
Well, my own view, but my own view doesn't really matter, is that that's again, remains within the jurisdiction of the Finance Committee. If the Finance Committee determines it wants to revise the policies concerning how we address issuances of bonds and notes, that's within the bounds of the Finance Committee.
That's fine. Let's be clear here. You're talking about the substance of the issue. And I'm talking about communicating it back to the Governance Committee and to all the board members to say that it is, you know, I've been asked for my opinion, however that might go, and that a letter should have been sent out saying that this item, or whatever other items are open, should be reported to the board members to say this is the purview of the Finance Committee. Then it lays there. That's all I'm saying. But I just find it disturbing that that there's something in the minutes of the previous meeting and it hasn't been resolved.
So let's get an answer to it.
Refer it to the Finance Committee.
It's referred to the Finance Committee. It's resolved. There's nothing more for us to do on that. Advice to council. It's a Finance Committee. There's nothing more to be resolved. Anybody else got anything else?
I have one question.
Okay, Jim.
You know, based upon all these new rules and regulations that we're going to be under, it's always, being an accountant, it's always, I've always wondered whether there was a way for us to segregate the cost of implementing all these rules and regulations and public authority. We send more information to Albany because we're a public authority. We have more rules and regulations, but every time we go to Albany, they look at our administrative costs and they say, oh, your administrative costs are through the ceiling. I'd like to know if there's a way for us to document what it costs for us to be a public authority and to live under all those rules and regulations. I think it would be phenomenal because, you know, every meeting there's something else that comes up that is a requirement because we are a public authority. But nowhere when I look at our financial reports do I see, you know, administration, public authority, law, or something to that effect. And I'm just wondering if we shouldn't be thinking, because I believe that it would be phenomenal and would be interesting for not only us to know, because we're criticized for having such a large administrative cost. A good portion of it is because we're a public authority.
Well, I certainly agree with you that complying with, you know, all of the various regulatory and statutory requirements consumes resources. I think, you know, these monitoring costs and transactional costs associated with that are difficult to measure. I'm not sure how we undertake such a study. I'm not opposed to such a study. It itself will, involve additional resources, and I guess if you were to go down the road of having a lot of time coding and things like that, you might be able to find a way to do it. That's something that, if you want, could be taken up
In order to finance.
service, yeah.
It's order to finance, I think. I mean,
Yeah.
Because I'm trying to get some of this going, since the legislation has taken effect. I think you raise a good point, and I've got to figure out a way, even if it were, sort of an allocation, type of formula where you say, okay, in order to compile this, and in order to keep the website updated, and in order to make sure, the information is reviewed, let's keep a little rough estimate of the time, and then allocate what resources go at that time, whether it's personnel, the, outside contractors when they, involved in that. Let me see what I can do with that, because I think that's a legitimate question. There's a cost of developing this kind of materials.
Okay, anybody else?
Yep.
Jeff, did you want to say something? Anybody? Motion to adjourn. Any all in favor? Anybody opposed? So moved.
Thank you.